The Catholic Church is opposed to the use of contraception, and the HHS mandate would require church-sponsored institutions to pay for their employees to use contraception. Doesn't the mandate violate the First Amendment?
It's requiring religious persons and religious institutions to carry out morally objectionable practices, or to be contributing to and making possible morally objectionable practices that are against their own church's doctrine and so forth. So it's infringing upon their right to carry on and abide by their church's teaching and still remain faithful as institutions to that church. The First Amendment is supposed to ensure free exercise of religion, and this, I think, historically in the United States has been understood to mean that you can, unless you're talking about something which contravenes good morality itself and thereby can adversely affect the public order. For example, a religious body could not practice human sacrifice or something like that, you know. When you're talking about things short of extreme situations like that, the religious entity has the right to abide by the principles of the faith that it is attached to and affiliated with. And this is obviously jeopardizing in a very direct way their ability to do that.
Why would the administration push for this mandate?
Well, I think that there's a definite opinion on their part, on the part of the administration and by Kathleen Sebelius, that contraception is a good. They think contraception is something is a good, and they think that women should have this available. And so they think that women have a right to have access to this.
Well, you know, it might be difficult to call it a pattern, but it sort of illustrates, when you look at the Hosanna-Tabor case and this now, it illustrates a certain kind of lack of attention to the question of the freedom of religious institutions and religious organizations. I mean, in the name of practices which the administration, which are in law, but the administration deems should apply to religious bodies as well, should apply to everybody. In the names of these things, it's kind of like a secular morality. In the name of this secular morality, these secular standards, even religious bodies cannot dissent, even if it involves intruding into the very function of their operation. For example, in the Hosanna-Tabor case, there was a case of a Lutheran school teacher, you know, and she was accorded a kind of ministerial status in the Lutheran church, and they let her go because of some issues involving her ability to function and so forth, and she raised a discrimination complaint. The point was, though, that in order to apply that federal law and the federal regulations pursuant to that law involving a matter of discrimination, I think it involved some kind of a disability discrimination question. It was a very problematic kind of disability, as I read about the case. That they would have to really kind of go into the internal operations of this church school and really tell them who they're going to hire and who they're not going to hire, who they're going to retain and who they're not going to retain. And it's something called the ministerial exemption, and the administration argued, as they're kind of arguing about this HHS regulation, that increasingly they're going in the direction of talking about a very narrow kind of interpretation of religious liberty. And they were arguing that except maybe for perhaps the ministers themselves in the body, or the priests in a Catholic church or an Orthodox church or something, that you can't control your hiring decisions if one of them wants to challenge this under federal law, you know. And the Supreme Court unanimously rejected that argument of the administration, that narrow kind of view of the ministerial exemption. They held the ministerial exemption to be protected under the First Amendment, not just a statutory exemption, but protected under the First Amendment. And the administration was turned back then.